Hello, my friends. It's Bradley J. and the Bradley J. Show. We're with Dean Michael Coyne of the Massachusetts School of Law today, and we're going to find out a little bit about the recent judgment against our former president, number 45, and see what are the chances that will stick, how much he has to pay up front to the court in bond, all the details you don't really hear about much. Also, there's another huge upcoming judgment in New York regarding his business case. And also, Judge Luttig is urging the Supreme Court to find that a former president cannot be on the Colorado ballot. So we're going to get into the details of all that with Dean Michael Coyne. How do you do, sir?
I'm doing well. How are you today?
Very well. As we can all see, there's a turkey out back there.
Lots of turkeys out there.
Which I think is cool. All right, recent judgment in the E. Jean Carroll case. First, can you give me a brief history of what, I don't know if you call them charges in a civil case, but what is alleged from the get-go? There was, as I understand it, there was a sexual harassment, or I don't know which
assault.
phrase to use, sexual
assault,
and then defamation, and then more defamation, which was a more expensive, at least thus far, defamation. Love to have you flesh that out for me.
Sure. She claims that a number of years ago she was sexually assaulted by the former president. And it's not just claims, because a jury heard her claims and awarded her an initial judgment of $5 million on the basis that she had in fact been sexually assaulted. Some use the term rape, but in New York, the act that he committed is not considered rape. It is instead considered sexual assault. Many other jurisdictions would in fact consider penetration by any thing as constituting the crime of rape, but New York did not. So the jury found that she had been sexually assaulted by the president, awarded $5 million in damage on her initial claims. And then he continued to claim it was a hoax, that she was a whack job, she was making this up, he never saw her. So she sued for defamation as well, because he was publishing false statements about her that were causing her damage. And as a result of that second set of claims, he turned a $5 million judgment into an $83 million judgment plus the initial five. So it's doubling down on a bad acts to begin with, have now cost him even more money because the judge heard the case and the jury, again, a second jury, found that she had in fact been defamed, and that between both actual damages for the defamation as well as punitive damages to make him stop, to punish him from continuing, even during the trial, he was still making defamatory statements about her. The jury found that he should suffer punitive damages as well. And so the total judgment for the second case, the second set of judgments issued in this case, the Jean Carroll case, was $83 million. So, you know, everyone can say he's a billionaire, he's got lots of money, but you're talking nearly $90 million between those two cases just to Jean Carroll. And that's an extraordinary amount of money, regardless of how much money you might have.
One quick note here. I know a lot of people have politics fatigue, and so every effort will be made not to have this be political at all, and simply an explanation of what's going on legally. That's what Dean Coyne does. That's what we always try to do. And now how much does the defendant have to pay up front while pending appeal?
Well, see, that's an interesting question you asked, because most people would think that if I am appealing a judgment, that I don't have to pay it in the meanwhile because the appellate court hasn't reviewed it and approved the judgment. But that's not the rule. Under the rules of civil procedure, that judgment goes into effect unless a party asks that the judgment be stayed, to be held in essence in abeyance pending appeal. But as a condition of it being stayed pending appeal, meaning she couldn't pursue efforts to try and collect that judgment, that oftentimes the court can and will, in fact, require a bond in order to ensure that when the appeals are all over, there will be compensation there that she will be able to obtain relatively immediately if, in fact, the appellate courts see that the judgment should not be set aside. So what we have in civil cases is the judgment will go into effect. He will likely be required to post a bond or cash for that entire amount plus interest, because remember, when the case goes on appeal, it could be on appeal for a year or two. A lot of things can happen in that time period. He could have financial setbacks, other creditors could come in. We know this other judgment from New York is going to come in. And so we want to protect her place and her ability to collect that judgment while he pursues that appeal. So he's likely to have to post a cash for the full amount or a bond. And the bond is just an insurance policy guaranteeing that that payment will be made at the end of the day. But in either event, this is costly and expensive and difficult oftentimes for him to be able to obtain that because the bonding company is going to look at what assets he has and what's available and charge a premium to obtain that bond and post with the court.
I see. So that way, a person who's awarded a judgment, if the appeal fails, doesn't have to go hunting down the person for the money, which could take forever. That's interesting.
Yeah, that's correct.
I did not know that. Is that something that is the case in most states?
Yeah, in most states and the federal courts as well. In this state and in the federal system, Rule 62 covers what we call stays pending appeal. And it's not automatic, and oftentimes there will be the requirement of cash, a bond, some type of surety, so that at the end of the day, there's recourse for that person to relatively more easily be able to collect the judgment. The alternative would be that judgment goes into effect even while they're pursuing the appeal, and she can start seizing Trump Towers and whatever other real estate or other assets she can find, completely disrupting his businesses in the meanwhile, because that guarantees that she has the ability to try and recover for that judgment. I mean, if you think about it, we have similar issues with respect to large money judgments from the Connecticut gun case. It oftentimes comes into play where the defendant wants to take that appeal, feels they have a meritorious appeal, but the question is, why should the plaintiffs, who likely in many cases have waited years already, wait even more years and potentially be devoid of any assets at the end of that process to be able to satisfy a judgment that the court has already issued?
It seems that most persons would have way long ago settled, even before the $5 million judgment. They might have said, "Okay, and here's $2 million. Let's be done with it." But this defendant chose not to do that. Is it possible that the defendant is confident that down the line he will be president again and can pardon himself, which is where this comes in?
No, not on a civil judgment. I mean, the pardon situation would be with respect to the potential many charges he faces in federal court with respect to the various problems throughout the East Coast and the 90 charges he faces. Not the state charges, but he could pardon himself on the criminal charges in federal court. But this is a civil judgment where it's been determined that he owes the money. There's no pardonability here. So I think, you talk about normal defendants and the rational things to do. This is not the case. This is his business model for many, many decades now, is what we would call a scorched earth defense, is that under no circumstances, until you absolutely have to, do you pay a dime or do you stop contesting? And that's what he's lived by. It served him well, and that's what's going on here. Most defendants forget the idea about settling and cut your losses. Most people would have shut their mouths and stopped saying the same things that defame her, that got him into trouble in the first place. And as one of the judges pointed out recently, he doesn't appear to have the ability to control himself when he's faced with opposition like this. And he's his own biggest enemy in that regard.
So it doesn't seem very likely that he will stop now, unless maybe $83 million is got the former president's attention. What happens if he does it again?
He'll be sued again for defamation. There'll be someone there, like on these cases, to assist her with it, whether it's politically motivated, that their assistance comes from. But at the end of the day, the jury has to judge the case on what the law is and what the facts are.
Okay.
And you would think, again, most people would stop, but instead, what we have going on now is we're castigating the court and the judge and all of the rest of it, when two juries have now come back with judgments saying that what he did to Jean Carroll, both initially and in more recent times, violates the law. And at some point, other people would simply shut their mouth and move on. The fact is, the likelihood of this case settling now is low until the appellate courts review it in its entirety and say either up or down.
Does the fact that this is kind of a second go around on the same basic, there's a second finding of guilty, reduce the libel? Sorry, guilty is a criminal thing. Reduce the chances that the appeal will be successful.
I think it does. I mean, when we write our briefs to the appellate court, when you start to want to advocate for a client, the argument will be, or the language that they'll use is two separate juries have found that the defendant did X, Y, and Z over a period of years. And the court has to consider that this isn't a rogue jury that went one way while outside the law. You now have two different courts at different times who have looked at this matter. Those juries were instructed, and I think appropriately, as to what the law would be. Based on the facts that they found in evidence, they issued appropriate verdicts. I think it's difficult then to argue that it's a system run amok, although that will be the defendant's arguments. But I tell my law students, what's the best way to win on appeal? Best way to win on appeal is win at the trial court level, and they've won twice. And
Right.
The fact is, most judgments are not overturned on appeal.
Okay.
Most of the time, there aren't mistakes that were made either by the judge in giving the instructions or the jury in weighing the evidence. And credibility is a factor that's left to juries to decide. Credibility is a significant issue in a case like this. You're not likely to see credibility determinations reversed on appeal simply because they didn't see the witnesses themselves, so they can't make that same examination that the jury did. We do have some issues on appeal that they will use, and already they've started to surface about, the judge had it in for Trump and his lawyer, and the fact is that the evidence was scant. But by all accounts, his lawyer didn't serve him well either. You can't complain about the judge being harsh with you. Judges are harsh. Here, she returned fire. And the fact is, the judge was, if harsh at all, was trying to school her on things that second year law students would have a better understanding than what was displayed in that trial. So the fact is that I don't think it's likely to succeed on appeal. I think the judge should have been less harsh at times with respect to the lawyers, the performance, and even former president's behavior in court. Although, in all honesty, if that lawyer was representing a different client, if that client wasn't the former president of the United States, my guess is that they both would have been held in contempt at various times for the disrespect shown the court. And it certainly is not appropriate behavior for any lawyer or client to display to a judge. And I do tell my law students that we need to be civil, we need to be professional, and whether you agree or disagree with the court's rulings, at the end of the day, you still need to pay proper respect to the court in a respectful fashion. That wasn't done by the defendant, who stormed out of the court on occasion. It wasn't done by his lawyer. And that may have invited some of the harsher comments from the judge, which I think the judge would have been better off tempering some of the comments as well.
One observation, and then we'll move on to the next case. But if it would seem as though someone charged with what amounts to sexual bullying to the extreme would not behave in court in a way to make it easy for the jurors to say, yeah, that's, the behavior in the courtroom is consistent with the charges, kind of. I would think he would be better to be respectful, and maybe the jury would say, oh, well, look at him. He's a former president. He acts presidential. Maybe he didn't do it. But it seems as though he was confirming at least the capability to do something like that with the behavior. I know he had I don't know if it's a strategy, and maybe it wasn't a courtroom strategy. Maybe it was part of a larger election strategy. Not sure. Or a fundraising strategy. Not sure. He's looking at the big picture, I'm guessing, or maybe not. Neither of us know the answer to that, so I'm not, unless you have a comment.
My comment is, I think that's a very astute observation. The fact is, again, this is something we teach law students to do, and it's a very difficult thing for law students, new lawyers to do, which is to control their client. The fact is, we talk about it. We can dress them up, and we do. We can tell them how to behave, how to look at the jury when testifying, how to use the appropriate words when discussing the victim or the principal witnesses against them, and not make it personal. When we're defending cases, we want the defendant to be a person. We want the jury to be able to look at them and see them as someone's little brother or cousin, or in this case, as you point out, someone not capable of committing sexual offenses and bullying someone about it, and being this over-the-top personality that thinks he can grab people in any manner he wants. The fact is, again, that whole act, if it was, or persona in court, didn't serve him well, as you're trying to convince the jury he just never would have done the types of things, and he didn't mean to cause her harm in defaming her. It's much easier for the jury to accept the allegations if you portray an unlikable character in court, and I think that's at least in part what happened here.
All right, let's move on to another case, which will have potentially more impact on the former president's finances. It's the New York business case, and some of the cases decided right out of the gate. There were other things that remain to be decided, but they will be decided this week, I believe. At some point, likely.
The likelihood is there will be a judgment this week with a massive fine, and the likelihood is there will be an injunction barring the president, the Trump companies, and the children, at least some combination of that group, from continuing to do business in New York because they have committed a violation of the business fraud statute in New York, which authorizes the court to undertake such a sweeping judgment as they are likely to issue sometime relatively soon.
All right. What happens after this judgment in terms of bond? Is it the same as with E. Jean Carroll's situation?
Well, it can't be. That's in fact correct. There'll be an injunction, which obviously would be reviewed pending appeal, and there'll be this massive multi-million-dollar judgment, perhaps 2 or 3 times the Jean Carroll judgment. And so they very well may have to post a bond for that entire amount as well in order to take it on appeal. So at the end of the day, and again, I know we believe he's got a fortune, but if much of his fortune is tied up in real estate, it's not likely in cash. And there has already been statements made that he better not think he can use campaign funds to pay either of these judgments, or he may face criminal charges if he does so. It's hard to believe that anyone making a donation to his campaign accounts would expect him to pay large civil judgments through that account. So there is a question about, who has 100 million here and 200 million there. After a while, that all starts to add up, is the old saying. That's a lot of cash to be able to have to post for those bonds to be able to pursue the appeal. So it will get more interesting the more these judgments pile up.
All right, let's say the judgment in the business case is X. What portion of that is damages, and who was damaged, and what portion of that might be punitive?
Well, I don't think it allows for punitive damage awards. It will be to compensate the state for the fraud that was committed, in essence, akin to some type of criminal proceeding, although it's not. The standard of proof is the civil standard of proof, and there's no right to a jury, as we know from our earlier discussions. So I think all of that money will go to the state for the fraud that was committed. You raised another interesting point as well. If the fraud was committed on the banks and other consumers in New York, why shouldn't that fund then be available for them to seek compensation for their losses?
Right.
I don't believe that the New York statute provides for that under the circumstances.
It is interesting because, I mean, they might have standing because they did suffer a loss. The loss in money between what a loan interest rate would have been if the company had given them the correct numbers on the books. If things hadn't been, well, just say, I don't want to say they were inflated, but if they were inflated, you got a better perhaps rate, and the bank is damaged that way. They lose the money between the difference in interest rates. So that, what is your best guess on the amount? You can't guess, right?
Well, we can all guess.
What kind of numbers?
My guess is as good as anyone out there listening. I think it's going to be between $250 and $350 million. That's been reported. The numbers we're looking at. That would not surprise me, and it would not surprise me if it's at the lower end, simply in order to say, see, I'm not as biased as you people have said all along. It's only $250 million. But that's, again, these are big, big numbers. Let's not fool ourselves in thinking that because he's a billionaire, if he is, that this isn't a lot of money. These are fantastic amounts of money for anyone to have to pay. And especially the other consequence is if, in fact, he, the children, or the organization itself can no longer do business in New York, that is an incredible blow to someone whose whole persona and business is based on his business acumen and his success. This will be a devastating blow to the organization and to the family.
Final topic here. Conservative Judge Luttig, hope I'm saying it correctly, seems to be, really conservative and a very thoughtful judge. The guy has a lot of sway. He's the person who, when Mike Pence was trying to figure out how to act when it came time to certify the election, Judge Luttig tweeted to Pence his feelings about how Pence should act, and Pence kind of followed that advice. And now, said Judge Luttig, is urging the United States Supreme Court to find that the former president should not be allowed on the Colorado ballot. I guess that's the test case for all the others. And that Article 3, 14th Amendment, really applies directly here. I wonder if a respected judge doing this and laying out the reasons why might have an effect on the Supreme Court's decision. And if what Judge Luttig says kind of sets the stage, and that kind of becomes the default, which may be more difficult to rule against than if he hadn't spoken.
I think it's easy to dismiss some voices, mine, yours, even George Conway, who we see on the news all the time criticizing the former president and making his personality diagnoses and the like. And so some voices are easier to dismiss. Judge Luttig is not one of those easier voices. But remember, this Supreme Court has a number of voices that they will listen to, that will have their ear, that will also be giving contrary opinions about what should and shouldn't be done here. The fact is, those voices will get an ear. The question is, at the end of the day, will they make a difference? You know, if you look back to just one of the most recent controversial decisions of the Supreme Court, the Dobbs case, there were many, many respected legal educators, lawyers, constitutional law scholars who said the Supreme Court could not, in good conscience, abandon the long history of the right to abortion and its own decisions, as evidenced by all of the various cases up to then. Well, they threw all of those opinions out the window when they said Dobbs that there's no constitutional right to abortion. So the fact is, while those voices will have the opportunity to at least catch some ears, I think what we've seen is that the Supreme Court will do as it ultimately decides the 9 voices on the Supreme Court want, not what other voices are telling them they must do out there. Although Judge Luttig is a voice that we all should listen to with respect to his opinions. He's well respected, doesn't appear to have the political bias that a lot of folks argue has infested some of our courts. But the fact is, at the end of the day, I think the 9 Supreme Court justices will do as it collectively sees fit, regardless of whatever opposition there is. Because as we know, Dobbs still to this day has created such turmoil and opposition to the court that they didn't seem to care what the repercussions would be.
All right. Well, thank you very much. We've gone about 5 minutes over what we planned. Folks, coming up, Dean Coyne is going to talk about Taylor Swift and AI. Can you explain? I don't want to get it wrong. What are we going to talk about?
Computer-generated porn, the revenge porn issue, and really what we're going to talk about is all of the associated artificial intelligence issues. You know, the fact is technology is way ahead of the law here. And so what rights are there for someone like Taylor Swift and others who have been hurt, damaged, and their image and likeness have been used in a way that they certainly would not approve of and that others may be profiting from? How is the law going to deal with all of these artificial intelligence issues that now seem to be everywhere? Because artificial intelligence is here much sooner than I think most of us ever expected.
Right. And in a related matter, speaking of AI and sex, there's a very respected author, Yuval Noah Harari, who said, no, actually, it's not him. It's another author. But there is a smart person who says sex with robots will be normal in 50 years. We'll see. We'll see. 50 years.
No, it's an interesting choice of words, Fred.
But that's exactly like the headline that I got. I didn't choose those words. And that AI is progressing so fast that you will actually be able to fall in love with a machine. Actually, not just sex, but in love with the machine, because they will know you better than you know yourself and be able to give you what you need. That's a whole other thing that we probably won't be addressing. Also, folks, what do you do if you get pulled over by the police? If the police want to talk to you, do you talk to them? Do you get a lawyer to be present, even though it seems like a small thing? You might feel uncomfortable saying, "Officer, I with all due respect, I need a lawyer to talk to the police." Also, if you get pulled over and you haven't had anything to drink and they want to do a breathalyzer, should you acquiesce? We'll find out the answers to all that. I tell you this because I don't want you to miss anything, and I want you to subscribe to the channel so you do not. It's the Bradley J Show. Also, there's the Bradley J Travel Channel. Dean Coyne, fantastic. As always, I love staying in touch. And we'll do this, the AI sex thing, sometime before the Super Bowl.
Sounds great.
Okay, thanks very much. This is will be not live in 5, 4, 3, 2.